My name is Candace Kednick, and I did my presentation on Pregnancy Discrimination Act of 1978. What is pregnancy discrimination? Pregnancy discrimination is treating a woman differently because of a pregnancy or a pregnancy-related condition. This doesn't just include employees, but this includes anyone applying for a position. This covers pregnancy and medical conditions related to pregnancy and childbirth. And work situations include all part of employment, such as the hiring, firing, training, insurance benefits, job duties, promotions, any of the factors that can happen within an office. All work situations is included in this act. What are the requirements? So the Pregnancy Discrimination Act only applies to employers who have 15 or more employees. Clients have 180 days to file a charge, although different states have slightly longer extensions, but it varies by state. And federal employees have 45 days to contact the Equal Employment Opportunity Counselor. All claims for a federal employee must go through this process versus a standard process. The first case that I looked into was the case of Young versus UPS. This was really interesting for me because it didn't turn out how I thought it would. So basically, Young was a part-time UPS driver who became pregnant. Once she was pregnant and restricted to lifting 20 pounds, she could no longer lift the 70 pounds, which is required by all UPS drivers. Under UPS's specific policy, they have that they only provide accommodations for people who are injured on the job, who lost their driving certification, or those who have a disability that's listed under the ADA. UPS wouldn't accommodate her request and force her to take unpaid leave since she was unable to perform her required job duties. The federal courts actually ruled in favor of UPS because they found out that under their policy, she was neither disabled nor injured on the job, and since that was the only stipulations that they would cover accommodations, they didn't find UPS doing anything unlawful. So this case went from the federal courts to the Supreme Courts because obviously Young really felt that she did have a case against them and she was being discriminated because of her pregnancy. So this moved to the Supreme Court and they ruled in favor of Young, but they didn't agree of her interpretation of the discrimination UPS filed. The court that held the case actually said that she should use the prima facie case treatment, showing under the McDonnell-Douglas burden shifting framework, she belongs to a protected class. She sought an accommodation. The employer did not accommodate her, and the employer accommodated others similar in their ability or inability to work. So this case ended up being a win in a way for Young, but more than just that, it became a win for all future pregnant women. Because of this case, they believe in 2008, that was a strong reason that an amendment was added to the PDA requiring employers to provide necessary accommodations to pregnant women with no stipulations. The next case that I looked into was EEOC versus Silverado. As I spoke earlier, federal employees use the EEOC to report any suits. So in this case, it was reported to the EEOC and they represented the client. So Mrs. Barton worked as a caregiver at Silverado Oak Village. When she became pregnant, Silverado, the facility, refused to place her on late duty to accommodate her medical restrictions and fired her instead. The Equal Opportunity Employment Commission, or the EEOC, filed a suit against Silverado on behalf of Burton. As a result, Burton was protected against future discrimination, retaliation, and awarded $80,000. Silverado also had to notify the public of the settlement, make adjustments to its current policies, report any job modification requests to the EEOC for a period of time, and provide management training to educate staff on the proper procedures. I think an important part of this case is how they added the regulations actually for the employer, because yes, they did have to pay a fine and they had to admit their wrongs, but they also made it mandatory that they had to properly educate staff so that a situation like this would not happen again. And then last but not least, this is my reference page. I hope you guys enjoyed looking at this slideshow, and I really enjoyed learning more about this act that is so important, especially to females. Thanks.